but it's a little bit more to that as well. But
Yeah.
cross examination is kind of where you get your more aggressive style approach seen. The purpose is to discredit the witness or their testimony. The purpose is to expose any biases or lies, contradictions. Uh, the purpose is to reinforce your case theory through them, through their testimony, and undermine the other side's narrative. So those are the things I try to focus on. You lead with questions. Um, you ask questions that suggest the answer, which is usually a yes or no. A lot of times people hate answering just yes or no, which at that time you have to gather them up and make it clear that you are responding to my questions and I'm asking you in the form of a yes or no. And
Mm.
so example would be like, you didn't see the defendant's face, did you? Versus, what did you see that night? Right? That's going to
Mm.
elicit two different types of answers.
That's that's
Um,
that's that's pretty
yeah.
good. That's tough.
Yeah.
And that's
So,
why they call you the poser. See, that's right. That,
yeah.
ladies and gentlemen of the court. But
But you want to stay in control. You don't want the witness to explain. You want to keep them on short answers. If they try to explain, you want to interrupt them politely and restate the question. You want to be clear, you want to be simple, direct, and just avoid those open-ended questions.
we have discussed how we're in court. We have discussed open statements. We have discussed cross-examination, examination, hostile witnesses, uh, learning how to navigate and what questions to answer, what questions not to ask. And now it's all over, and we have our closing statements, closing arguments.
Okay, so now you're in closing, and like I mentioned with opening, the same way you would want to introduce yourself and greet the jury, you want to thank that jury. You want to acknowledge the time that they spent because people are leaving work. Some people can't afford to really take off work, so it truly is um, a village effort in that you're pulling people from your work. You want to recognize that, and they can appreciate that. You want to thank them for their time, their service. You want to restate that theme by reminding the jury of your case's central theme or whatever that theory is. You want to summarize that key evidence, right? Review the most compelling testimony. Go over those exhibits. You heard her deposition testimony. We brought the pleading to her deposition testimony. The pleading she said that she read and went over and reviewed and filed along with her attorney. She claimed permanent disfigurement. Do you see any permanent disfigurement today? Because now that we're in trial, now we're in front of the jury, we're no longer behind paperwork, we're no longer hiding behind medical records. You're able to see firsthand what disfigurement looks like, and that's not what that is today. Right? So you want to
That's
talk you,
hold on,
you
time out. Let me tell you right now, if that's not your lawyer, if, uh, listen, if that's not your attorney, Gucci, you're cooked. Hey, what Future say? Ain't
uh,
no way.
yeah.
That's good.
Right. And remind the jury, why are we all here to begin with? We could talk about this all day, but at the end of the day, if it's criminal, you got to remind them of the burden of beyond a reasonable doubt, that it is the highest burden you can meet. If it's civil, you refer them to the preponderance of evidence. I just need 51% over 50%. This is
Mm,
not criminal court, a
mm.
preponderance of evidence. And then,
And that's what I love what Brooklyn brings to Keep It Legal off the record is the ability to think sharply, think quickly, and to be able to process a lot of sometimes arduous and complex information